I will share with you that before Katrina, and when I would watch the news about Beirut, and even going back to the, watching the fighting in Ireland and the wars here and there, and I thought to myself, God, what must it be like to walk down a street, where the buildings are bombed out and there's nobody there? Well, I'm going to tell you something. What we lived through in Katrina wasn't a bombed out city or a destroyed city, but it's as close as I ever want to get. I grew up in this city, and in fact, my parents lived at the lakefront. Our home was within about 200, 300 feet of the levee. And as these hurricanes would approach our city, we would run to the levee, and we would watch the surge roll in, the tide and the big waves, and they would splash, and it was really quite exciting. What's important for everyone to understand, I'm a child, I'm standing on that levee. Never in my wildest imagination did I ever believe that levee could fail. It's like walking into a building and getting into an elevator and the elevator crashes. It's like crossing a bridge and the bridge just falling out from under your feet. The last thing that we as Americans would remotely suspect is that the greatest engineering firm in the world, so named because they were able to build a Panama Canal when no one else could, the greatest engineering firm in the world caused the flooding of this city. Not Hurricane Katrina, the United States Army Corps of Engineers. This organization is responsible for the health and safety of millions of people. There are levees all over this country. Now think for a moment about whether or not that levee is actually going to do what it's intended to do. Think about the fact that the Corps tells us that they performed as designed when they fell down. Think about that outrage. Did you know that water that went over the top could make the levee fall down? No one knew that. So now what we have, instead of a Corps of Engineers that says we're going to make a better levee, you know what we have? We have a Corps who says we have built levees to reduce your risk. In other words, folks, you're all at risk for flooding, and all we're trying to do is reduce the risk. Well, that wasn't the bargain that I made, or at least I understood that they made, and that's what outrages me. There's a group of people in this community, and we call them Creoles. They are African Americans. There was a group in the community, and they were tradesmen or craftsmen. They were your bricklayers, they were your sheetrockers, they were your ironmongers. And when I tell you that you see brickwork, you've never seen brickwork like brickwork done by a New Orleans Creole. One of these gentlemen was a man named Andrew Reeves. He was an ironmonger. His son did unbelievable things with iron, the curls and all this stuff. He's about 80 years old. He came to see me after the storm. He says, Joe, I lost my sister. I lost my business. I owned my house, Joe. I owned my house because they told me to pay it off. That's what you did when you worked your entire life. You paid off your house. And Joe, when I paid off my house, I didn't buy any flood insurance, because the only reason why I had flood insurance in the first place is because the bank made me do it to cover their mortgage, not to protect me. People bought flood insurance to protect the bank. He lost everything. And as he stood in this room and cried, I tried to figure out what I was supposed to say or what I was supposed to do. I felt like I should be doing something. I should say something. I couldn't think of anything to say. I'm not that smart. And the only thing I could think to do is what I do, which is to file a lawsuit, which is what we did.
Today, the Insider Exclusive goes behind the headlines in Katrina Justice, a preventable disaster. To examine how Joe Bruno, managing partner of Bruno & Bruno, who serves as the court-appointed liaison counsel for the Katrina Canal Breaches Consolidated Litigation, and Scott Joannan, one of the many lawyers on his team, have led the efforts on behalf of the citizens and residents of New Orleans who suffered catastrophic losses due to the gross negligence of the United States Army Corps of Engineers, which caused the flooding of New Orleans. Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from New Orleans. It is my great pleasure to introduce Joe Bruno and Scott Joannan to the show. Welcome to the show, guys.
Thank you.
Thank you.
Today we're here going to be talking about the MrGo litigation. We're going to be covering some up-to-date information, but before we get into that, in case someone doesn't know what the MrGo litigation is, just summarize for them.
Very briefly, after the storm, everybody knows the city was inundated with floodwaters. Everybody generally knows that the reason why we were inundated was because of the neglect of the Corps. And so one would ordinarily and reasonably expect, well, if they were responsible, why didn't they come to justice? Why didn't they write the check? Well, the fact of the matter was that the Corps at that time enjoyed, and still does, an immunity. You can't sue them. So our goal in filing this litigation was to see if we could find a way to get redress. Number one, to make the Corps accountable for their neglect. And two, to see if we couldn't change the way they do business, because you know the Corps operates not just in New Orleans, but all over this country. So our real goal was, as I said, one, compensate the people of this community who had the most horrific experience of their lives, and two, see if we can make these people at the Corps understand that their negligent acts will have consequences.
Right. Now, let's talk about this issue of immunity. The Flood Act of, I think it's 1928.
1928.
Gave them immunity in regards to building
Correct.
flood canals.
Yeah, and the logic was, you know, the Congress says to itself, well, what we're going to do is we're going to build flood protection along the Mississippi River. We want to make certain this doesn't happen again. But they thought to themselves, now wait a minute, if we do this, we don't want to invite liability. So the compromise was, okay, we are going to do this, but we are going to immunize ourselves for damages that may result from the design, from the construction, or from the maintenance of a flood control project.
Right. Now, when you say "and the maintenance," the maintenance was the issue, really, of why you won your case to begin with, right?
Well, actually not, because what we did was, well, of course, we filed suit against the Corps for all of the flooding in all of the polders or bowls in the city.
Yes.
The only one that was successful was the one which suggested that the levees fell down not because the levees were designed, maintained, or constructed improperly, but because a MrGo channel, which was separate and apart and had nothing to do with the flood control, was negligently maintained. So you're correct about that.
Yes. Now, we have with us today a news clip of one of your leading experts, who's
Dr. Ivor Heerden, yes.
Right, who's going to explain, and it's a real brief one, who's going to explain why these levees failed to begin with. So let's go to that right now.
Now, what went wrong? When you design a levee, you got to come up with an idea of how high the water could get in your design storm. And they call that the standard project hurricane. Now, it was devised because we had the 1965 Flood Control Act that called for the most severe meteorological conditions considered reasonably characteristic for that region. This was after Betsy, which was a Cat 4. Not long after this, we had a Cat 5 Camille. So one would assume that they would have been thinking about at least a Cat 4. But they didn't. The Corps of Engineers used a 1959 definition, and the key thing, the winds were only 100 miles an hour. The National Weather Service then contacted them and said, hang on, this is too weak, we're upgrading it. And in 1981, they were ordered to change to the new definitions, And the New Orleans district ignored that order. They were still designing on the 1959 criteria.
He was, by the way, Dr. Ivor Heerden, he was really trashed as a matter of coming forward and telling the truth, wasn't he?
There's no question about it. Ivor came to me, well, first of all, Ivor was the spokesman for the neglect of the Army Corps shortly after the storm. You know, there was a tremendous amount of media attention brought to our community. Ivor was on TV every day and kept pointing the finger at the Corps, kept pointing the finger at the Corps. Well, LSU didn't like that very much and told him, if you continue to do this, if you work with the plaintiff lawyers on this case, you will be fired.
Right. Someone within the government must have been telling LSU, if you want to continue to get federal funding, you keep this guy's mouth shut.
You know, and if they didn't say it, it was certainly nod, nod, wink, wink, because we went all over the country looking for experts to help us understand this case. And everywhere we went, we got the response, simply, we work for the Corps. They never said, they told us not to. They simply said, we work for the Corps.
Now, there are 4 types of litigation. Explain to our audience the 4 types of litigation involving this whole catastrophe.
Well, there were, as I said, after the storm, there were hundreds of lawsuits filed. The federal courts had to figure out a way to deal with it, to manage it properly. So they allotted all of these cases to Stanwood Duval, primarily because most of the other judges had been impacted by the storm. And so as a result, had to recuse themselves. So when they all came to that judge, the judge said, we need to divide these things up into some component parts. Well, the first group of litigation was the insurance litigation. Very briefly, it was our allegation that the flood exclusion in everyone's policy ought not apply because it wasn't a natural flood, it was a man-made flood.
Yes.
Just the same way as if I was driving on the street and someone hits me, I should be able to sue that person who hit me, and my insurance shouldn't not pay because there's some exemption. That was the flood insurance component. Then there was the levee, what we called levee.
Right.
But that has a peculiar meaning. That meant the litigation that regarded New Orleans proper, where we're sitting today, where the French Quarter is, and the levees that ring that area. The third grouping of litigation was the MrGo litigation, and that was litigation that regarded damages alleged to have been caused by this not flood control project, but this navigation project. And then finally was the barge litigation, and that was an allegation by others, not us, because we frankly didn't buy it, that the barge was negligently moored, and it was the thing that broke the levee. Of course, that went to trial, and they lost.
Now, Scott, you were very much involved with this litigation too, weren't you?
Yes.
And there are a number of other lawyers, a whole team of lawyers here. This has been a major effort on behalf of many different law firms.
Correct.
There was an initial court decision in 2009 in Judge Duval's chambers, right, in his courtroom, which tell our audience a little bit up, because everybody knows about this, but what was the main reason why he decided in favor of your plaintiffs?
I would have to say it was because the teamwork, obviously. We defeated the 702C immunity, and we were able to defeat the discretionary function exception with the application of what's the NEPA, we called it, but it's the National Environmental Protection Act. But then more importantly, the MrGo itself, the contribution of water was not as important a factor as the wave action that was allowed because of the negligence of maintaining the channel. And the waves ate away at the face of the levee. And the theory that the plaintiffs presented was that the high water mark had to be at a certain time. The defense's theory, for it to work, had to be at a different time. And we were able to show in Joe's cross-examination of one of the core experts, showed that their theory could not stand muster.
They never expected you to do this type of investigation to find that, right? And it was a difference of when you're talking about the high point when the waves hit. It was the difference between 1 hour, right? 8:30 and 7:30.
Absolutely. And what's fascinating is that we were able to show the experts, to put it politely, messed up on so many different issues that the experts were changing their methodology in the middle of the trial.
Yeah, I remember reading in your summary when you sent it to us. the fact that when you asked their expert about this very same thing,
Yeah.
he refused to answer the question.
Right.
And when he said he refused to answer the question, did he just ignore you?
He just ignored me, and then the judge got frustrated and said, "All right, I'm taking over." And he turns to the witness and he says, "Now let me just ask you this question:
Yeah.
If the peak surge, which is if the time that the water got to its highest,
Yeah.
was at 8:30 instead of 7:30, does your theory work?" And the answer was no. Well, their own experts agreed that the peak surge was at 8:30, and so they lost.
I think it's important to bring out that Dr. Heerden had been using any way he possibly can to bring out the fact that this was going on, right?
Exactly.
In fact, going back to the Gracie case, wasn't it made known to the U.S. Army Corps of Engineers at that time that they needed to make some changes in what they were doing?
There's no question. The people of
And they chose not to do it.
Yeah, they've been complaining about they were frightened because what happened in Betsy was unprecedented. You know, the waters came in and flooded Betsy back then. There was an allegation they blew up the levee, all this craziness.
Yeah.
But the bottom line is the people, without being scientists, believed it was the channel.
Yeah.
The Corps did its own scientific testing,
Yeah.
and even though they didn't share this with the public, one of the evaluations revealed that the channel did make the water higher, but they didn't tell anybody.
Yeah.
But there were two other evaluations.
Did you get that information, by the way? Were you
Yes,
able
we
to
did.
get it?
Absolutely. Ultimately, we
I'm
did.
surprised they didn't destroy it.
Well, yeah, particularly since we found evidence
Yeah.
of the fact that they would take a test that showed that it was a failure and then
Yeah.
turn it around and said that it was a success. That was
Yeah.
something we found as well. But you're absolutely correct. The people had the gut sense, but we, and I'm so proud of this because we successfully demonstrated scientifically that there was, in fact, a causal relationship.
Now, let's get to the good news. Yesterday,
The good news,
what happened? What
yeah,
happened?
as I
And
said
by
to
the
you-
way, before we get to the good news, I want our audience to know that in 2009, the hurricane happened in 2005. We'll look at the timetable. 2009, you
Trial.
won your first case at the trial level. It went to the appellate court because the United States government appealed it. And yesterday, what happened?
Well, yesterday, as I said when you came in, I thought you must have some kind of magic bean
We brought
or
that
something.
news.
You brought the news. You brought us the good fortune. But we learned last night, quite literally at about 10 minutes to 6, that the Fifth Circuit Court of Appeal has actually affirmed the decision. And of course, we're so overjoyed because everyone knows, and it's not to say anything detrimental,
Yes.
the Fifth Circuit is notoriously conservative.
Yes.
But we had an extremely conservative panel who ruled 3-0.
Wow.
That this decision should be affirmed, that the immunity, the 1928 immunity, doesn't apply.
Right.
The discretionary function immunity, which is a broad-based, where you get to do whatever you want, essentially,
Yeah.
if you consider policy, didn't apply.
Right.
And affirmed this decision, and did it in a way which I believe makes it unlikely that the Supreme Court will grant any writ.
I kind of overheard you, I think it was you, Scott, that said the judges, the justices, wrote in their decisions something that they heard the prosecutor say. For the what was that?
Heard the
Prosecutor say
the
something
defendants.
about this is our fault, we screwed up.
Oh,
or
yes.
whatever. What exactly? What
the
was
attorney for the government at one of the motions when they were trying to get the case thrown out.
it? Yeah, and what was her name?
That was Robin Smith was his name.
Okay.
He basically said in a very pompous way that we knew that the MrGo was causing these troubles and that the
He said that in the courtroom.
in trying to get the case
Yeah.
dismissed.
In argument.
Yeah.
We knew full well that they had all these problems, but we're still immune because of the discretionary function exception.
And the
way we
justices
considered it.
incorporate that in their decision.
They looked at that.
It's in the
Correct.
decision.
So therefore, when it goes to the United States Supreme Court, and they plan on appealing it, don't they?
They've told us that we're not paying any money until you peel our cold, dead hands off this cash registry. So
Yeah.
And they've also filed a motion to say that each person who has been damaged in Katrina has to come out and retry the entire case. So the millions of
What
dollars
kind
that
of
were
nonsense
sent.
is that?
that's our government at work, because what they, it just goes to
So you
show
got a decision for the 6 people.
Right.
So each person has to come out and try their own case?
That's their position.
Okay.
Yeah, their position is, well, you know what, we really don't want to pay, even though, one, we know we did something wrong, we know we've been negligent, we know and even in the other case where they had immunity, we know we did something wrong.
Yeah.
But we're not going to pay, even though we have a judgment against us. We're going to make this as difficult as we can for you,
Yeah.
which
Now,
is sad.
Let's talk about liability here, and I'm going to compare it to 9/11. 9/11, there were 3,000 families there was $7 billion dispersed to these 3,000 families. We're talking a lot more money here, aren't we?
We are. We're talking about, I think, well, the total liability for all of the flooding, the Corps itself estimated in its fiscal report from 2007 to be upwards of $100 billion.
Yeah.
Certainly, we didn't win for the whole case, so
Right.
it's a portion of that amount. So I would think that it's in the $10 to $20 billion range, but and I have to say that we recognize that the government should and will get a credit for the grants that they gave the folks who were in these communities.
Right.
We have no problem with that. It's the uncompensated component of people's damages, particularly the personal injury, the wrongful death, that we think needs to be recompensed.
I want our audience to know that when you guys take on a case, you're not looking to settle the case. You're looking to go all the way, aren't you?
Well,
because let me bring this up. This case, for the 6 clients that you have, you won $700,000. But you and your group has spent in excess of $10 million.
$10 million,
so far in this
and
case.
I have to say, there are 20 law firms, not just us. We didn't do this by ourselves. There are 20 of the law firms who joined with us. And these are the heroic lawyers who put up their money and put up their time on a case that most thought impossible because it was the right thing to do. This is what lawyering is really all about. This is what a plaintiff lawyer does day in and day out. It's not the relatively easy case with the big payout where you get the big check and you go home. Most lawyers have cases like this. Tough, hard to litigate, expensive to try.
Our congratulations to you, and I want to thank both of you for being on the program.
Thank you. You're more than welcome.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.